Litigation, the conduct of a lawsuit, is a process. Legal shows on television would suggest that it's a process that begins and ends in 45 minutes. The reality is quite different. Litigation in British Columbia is a process with 10 stages. From start to finish, it takes approximately 15 to 18 months. The goal for our clients is to achieve the best settlement we can without taking our clients through the entire 10-stage litigation process, ending up with a trial. The first stage is the pleadings. Pleadings include the notice of civil claim. That's the statement in writing of the plaintiff's case, the plaintiff's story. There's also the response to civil claim, which is the story of the defendants. We then move to the next stage in the litigation process, and that involves the discovery of the facts. The discovery stage has two components. First of all, discovery of documents. What that means is each party has to disclose, and the other side has to discover, the other side's documents. In this day and age, the documents can be hard copy, they can be documents from emails, texts, or any other form of digital writing. So there's a list of documents of the plaintiffs, and there's a list of documents of the defendants. The second component of the discovery process is the examination for discovery. It's an opportunity for both sides to have their witnesses tell their story. They involve a representative of each side with their own lawyer being examined by the lawyer for the other side. At the end of the examination for discovery process, everyone has a better sense of what their case is about and what the other side's case is about. And that very often leads to a discussion about settlement, and quite often leads to settlement itself. If one or other side is not disclosing the documents that are required, you go off to court to get an order that they do so. Without going into great detail, there are a number of different applications one might have to make to a judge along the road, and these are called interlocutory applications. There's always an opportunity for an early resolution of the litigation based upon what's transpired during the course of the discovery process. And that early resolution is called a summary trial. This is not the trial itself. There's no live evidence. You go before a judge to say the case is so clear based upon admissions obtained at discovery that this litigation ought not to go to trial. It can be resolved at an early stage. Witnesses can be lay witnesses. Those witnesses who are privy to the actual facts, who can give evidence about what happened on a particular day with regard to a particular transaction, etc. There are also expert witnesses, forensic accountants, appraisers, business valuators, and the like. Finding the witnesses, interviewing the witnesses, determining the evidence that needs to be led at trial is the next stage in the process. A fair amount of time is devoted by lawyers to the preparation of the legal submissions, the legal arguments for the judge at the conclusion of the evidence. In the month before trial, the lawyers sit down with the various witnesses. We prepare not only our examination in chief, which is the witness's story, but also the cross-examination of the opposing witnesses. Civil litigation often settles on the courthouse steps. By that we mean the Friday afternoon or the Saturday or the Sunday before the trial that starts on Monday. Both sides generally recognize that there's an advantage to achieving a negotiated settlement that's acceptable to them rather than going to trial. But in those cases where a negotiated settlement is not possible, the trial does proceed. On day one, both sides, the plaintiff and the defendant, make their opening statements to the judge. When that's concluded, the plaintiff then starts to lead its witnesses. Each witness is led in chief, in which they tell their story. They're then cross-examined by opposing counsel. There's also an opportunity for some re-examination by plaintiff's counsel if necessary. The defendant leads its witnesses in chief. They're cross-examined. There's potential for re-examination if necessary. And at the conclusion of the defendant's witnesses, the evidence, the evidentiary part of the case is now complete. What follows from the evidentiary case is the legal submissions. That's both lawyers, one for the plaintiff, one for the defendant, putting forward the legal submissions based upon the evidence that's just been heard by the judge. The judge then goes away for what could be a month, 2 months, sometimes as many as 3 or 4 or 5. And that's a good thing. That means that the judge is giving your case the fullest possible consideration and coming to the right outcome. Litigation is not for the faint of heart. It's an adversarial process, and we as your lawyers are your advocates to help you achieve a success in that battle. I urge you to pursue your rights and your remedies vigorously and through to a successful conclusion. If we can be of any service to you in that regard, we invite you to give us a call.